Hi, welcome. It's May 27th, 2026. I'm here at Russo Law Group, and I'm happy to welcome you to our webinar entitled Planning for a Loved One with Special Needs. Before we move forward, let's start with some housekeeping items. Your microphones will be muted for the next 30 minutes. The recording will be emailed to you. Please feel free to share your comments in the comment box and submit all questions in the Q&A box. Additionally, we value your feedback, so please submit your feedback once the survey is presented to you at the end of the webinar. Please meet the presenter, Deanna Ebley. She's a partner here at Russo Law Group. She has 25 years experience in the practice areas of special needs planning, elder law, Medicaid planning, and estate planning. She's a member of the New York State Bar, the Nassau County State Bar, the Nassau County Women's State Bar, Nassau County Women's Bar Association, and she serves on the executive committee of the New York State Bar Association Elder Law and Special Needs. Deanna, I'll hand it over to you.
All right, perfect. Thank you so much, Cindy. Welcome, everybody. I hope that you're all recouping from your rainy weekend. What we're going to cover today is creating a financial and legal plan for your loved ones with special needs. The role of a special needs trust in protecting eligibility for benefits, preparing for future care, and ensuring long-term security. So the first thing we're going to talk about is supplemental and special needs trusts. So one of the things that is often asked in consults and in seminars is, well, what are the benefits? I've spoken to friends, I've spoken to family, I've heard of this concept of supplemental needs trust. What are the benefits of establishing that for my loved one? One of the benefits is asset management. The biggest benefit in this case would be maximizing government benefits like Medicaid and supplemental security income, otherwise known as SSI. Supplemental special needs trusts come in a few different forms. You have your third-party supplemental needs trust, a first-party special needs trust, and they can be revocable or irrevocable, and they are funded with assets, often a house or bank accounts, life insurance, retirement accounts. So we're going to get into a little bit more detail to break down the different types of trusts so that you have an understanding of what each does and how they can help you. So the first one we're going to discuss is the third-party supplemental needs trust. Third party means it's not being funded by the assets of the disabled individual. So they're established for the benefit of a person with special needs, and the funding, so putting in bank accounts or property or the like, is coming from a third party, like a parent or a grandparent. Because it's not an asset of the disabled individual's own, there's no payback provision to Medicaid, which just means that at the end of the day, when the beneficiary passes, if they were on Medicaid, Medicaid does not have a requirement that they need to receive funds reimbursing them for anything that was paid out before anybody else can benefit from this trust. So if a parent set it up for one of their children and they have other children, they can establish this trust. And in establishing this trust, they can set it up for one child, and on the passing of that child, it can go directly to the other children if that's what they wish. The settlor or the person creating the trust controls where the trust assets go on their demise and on the demise of the beneficiary. So that's the biggest perk and one of the reasons why this is so important, because you're not ultimately letting that special needs person inherit the assets first. You're setting it aside before they inherit it But as we said at the beginning, it's established for the benefit of that beneficiary. That's distinguished from the first party special needs trust in that a first party special needs trust is established by the disabled individual. So I'll read that again. It's established by the disabled individual or a parent or a grandparent or a legal guardian or the courts. It is for the sole benefit of a disabled person under the age of 65. So if somebody is over the age of 65, this trust cannot be used. It is funded with the disabled individual's own assets. It is used to protect the assets and the income of a person who is disabled while accessing government benefits. And in this case, there is a payback to Medicaid. So by that, I mean, if I were a disabled individual and I had, $30,000 and that $30,000 was making me ineligible for benefits, I'm under the age of 65, I can establish this first party trust. I could put the $30,000 in there. I can use the $30,000 for my benefit, but on my passing, if I was on Medicaid in that time period that the trust was established, if there were $5,000, for example, left in the trust, my husband and my kids don't get access to that 5,000 first. The first person who would get access to that 5,000 is Medicaid. Now, if Medicaid didn't pay anything for me, then it can say that my husband inherits. If Medicaid paid only $2,000 of benefits for me, then Medicaid would get the first 2,000 and my husband would get the next three. But Medicaid in this scenario where the money, if I'm the disabled individual and the money was my money establishing this trust, then Medicaid has the right to get paid back first before anybody else gets paid back. And because of the structure and the goal of accessing government benefits, this particular trust has to be established as an irrevocable trust, meaning essentially it isn't changeable in my lifetime. Okay. Another type of trust that's often used in circumstances where we're talking about trust for disabled individuals is a pooled trust. There's multiple types of pooled trusts. It's an alternate to the special needs trust because a pooled trust is a trust that is established with a charity instead of paying back New York State or Medicaid. Often the charity ends up getting the money at the end of the disabled beneficiary's lifetime. There are about 22 or so pool trusts in New York. We often refer to the Teresa Foundation Pool Trust. They have multiple types of pool trusts that are income and asset based. So somebody who is on looking for Medicaid home care and they're a disabled individual looking for Medicaid home care. Medicaid home care has guidelines for how much income somebody can have and still qualify for Medicaid without having to contribute any income to the cost of their care. So I'll use some round numbers. Roughly $1,800 a month is allowed as income. And if somebody had $2,800, they would have $1,000 excess. If that $1,000 is needed for their monthly expenses, like their mortgage or to pay their rent and stuff like that, then you would jump to a pooled income trust because a pooled income trust is a trust established with a charity that allows for you, instead of taking that $1,000 and using it on the cost of your care, you can give it to the charity. And then the charity has the benefit of being able to spend the money on your monthly expenses up to what you put in. And you still have access to those funds through the charity. So there's a lot of upside to having a pooled income trust when Medicaid is involved. The caveat there is that when it comes to the income, the pooled income trust cannot be established for somebody who is in a nursing home. Income of the individual receiving Medicaid benefits in a nursing home goes to the facility as the priority payer, and then Medicaid is the payer of last resort. So while you can establish the pooled income trust in circumstances where there's a home care scenario, once somebody goes into a nursing home, you have to stop funding that trust. You could keep spending the money on that trust, in that trust, but you can't keep funding that trust. Okay. I just want to mention one other thing, and I think, Cindy, that I forgot to have you put it on a slide. Another trust, and you might want to go back to the slide we were on. Another trust that's out there and that is often used in combination with a lot of these other things that we're talking about is an ABLE account. So an ABLE account is similar to a pooled trust, but the upside to an ABLE account is in circumstances where you have a child with special needs that is on SSI. Using any of these types of trusts for that child to pay for housing expenses will cause the child to lose 1/3 of their SSI benefit because of the housing expense being paid for by somebody else, i.e. the trust. In an ABLE account, which can be funded up to $20,000 a year currently, um, you can take $20,000, put it into an ABLE account, which again is established with a charity, and that $20,000 can be used for expenses throughout the year, such as paying for the rent. And then the individual who is on SSI will not lose any of their SSI payment um, because it is a carve out under the law and allows for that benefit to still be maximized. So oftentimes you will see families use trusts, multiple trusts in combination with one another to maximize their loved one's benefits while still giving them opportunity to use and enjoy everything that is available to them. Okay, you could go to the next. So one of the other big questions that we get, especially in the circumstance where we're talking first party or third party trust is, well, I want to establish this trust. I really need this trust. I will benefit for this trust, but how do I decide who's going to be the trustee of that trust? Because you always want to keep in mind that the trustee is the person who's going to manage money. And when they're managing the money, you want to make sure that they're good at managing the money. You don't necessarily want to put, for example, a sibling in who has declared bankruptcy once or twice, and at the end of the day, they're the ones that are, you know, you're feeling you have to name them as a trustee. So some of the options, it's a very important decision that has to be made. And some of the options are first look to family. Do you have family members that you know are good at managing money and they understand the ins and outs of things? They can have a conversation with the attorney that's establishing the trust, and they know that they can grasp the concepts, understand what can and cannot be paid for, and they're going to help you budget the money that's in the trust so that it stretches across your lifetime and isn't just paid out in large sums that depletes itself fairly quick. If the answer is no when you get to the family level, then you certainly can look to friends. I probably would jump to professionals because there's a number of companies out there that use that professionals are a big way of dealing with this. And it could be professionals like an attorney, your attorney or your accountant, Or it could be something on another level, like corporate professionals at a bank or a trust company, where this is all that they do. This is their niche, and they are managing and paying out from these trusts daily, and they know all the ins and outs and can help you maintain your benefits and work with you to keep budgeting so that you're not overspending things. And then certainly with the pool trust employs their own trustee so that there's continuity, because they have to make sure that everybody who's in that particular charity's pool trust is managing things the right way, and they're not um, mis mismanagement of one person's account could affect others. So they want to make sure that there's continuity across the board. So we've been talking about some of the government benefits, but I just wanted to give an overview and remind you of the benefits that often are we're looking to protect when we're talking about these different types of trusts. So when we talk about money, like an income source, supplemental security income is SSI, and that is a stipend that is given to somebody who doesn't have another source of income, and they didn't work in the Social Security system for enough time, so they're not collecting Social Security benefits, and they still need to have a way to, put food on their table and a roof over their head. Social Security disability insurance is for somebody who worked in the Social Security system and they are not necessarily old enough to collect Social Security retirement benefits. They had an accident, or there's some kind of disability that's forcing them to not be able to work in the system anymore. And so Social Security is saying that they're going to start giving them their benefits sooner. The upside to this versus collecting Social Security retirement is in a case where somebody is collecting Social Security disability insurance, SSDI, that person is collecting their Social Security benefit now as if they made it to their full retirement age, and they get the full benefit that they would have gotten had they made it to their full retirement age, which for most of us nowadays is 67. As opposed to somebody being like 62 and they're looking to collect their Social Security a little early. If you collect Social Security starting at 62, not under a disability, then you take a percentage, your payment is decreased by a percentage because you're taking it earlier than your full retirement age. So you don't get hit with that penalty if you are younger and collecting Social Security disability insurance. You collect your full retirement benefit. We also talk in terms of the medical side of government benefits, and that is the insurance aspect to it. So some people may have private insurance that, like United Healthcare, AARP, GHI, Blue Cross Blue Shield, that is paying for some of the things that they need. But there's also that Medicaid component that can help pay for any uh, medical gaps that are there, like home care services or nursing home services. Okay. So you understand the difference between the financial and the medical aspects. And now it's just a little background with regard to how they're looked at. So SSI, which was the stipend for somebody who didn't work in this Social Security system, SSI and Medicaid in some respects mirror one another, and they are both financially means tested, which means that you have limits as to how much you're allowed to have in assets and income to qualify for those benefits. They limit the assets and the income allowed because it's a benefit that's being offered, and we want to make sure that you're qualifying for it. So like SSI, You can't have more than $2,000 in your name to qualify for that benefit. Where Medicaid right now for home care and nursing home care, the person needing the care, you can't have more than $33,038 in your name to qualify for that benefit. So, sometimes you're able to take steps to qualify yourself, and sometimes you take those steps, and in taking those steps, you have a waiting period before you then qualify. So, next slide. So because a lot of what we talk about is planning in advance, and there are certain things with SSI and Medicaid that can need a little bit of a waiting period, we think in terms of if you have an individual who is a child and they have some disabilities, and we want to anticipate their needs as they become 18, which is legally the age of majority, or then you want to make sure that you're planning in advance, because if they have money from holidays and the like, and you've got it in their name and they have more than $2,000 and they give that away the month before they look for SSI, they're not going to qualify for SSI because SSI looks back 3 years to see what kind of transfers were made. So you want to start preparing for somebody who we know is going to need this service before the age of 18. So by 14, you want to start moving money out of their name so they're not caught up in that 3-year look back. You also, as a parent or a grandparent, might want to review your documents, your wills, your trusts, and advance directives to make sure that you've established certain parameters to allow that individual to inherit, but in a protective way. And it's always recommended that you do a memorandum of intent so that if you should pass, somebody has some guidelines on doctors that your child goes to, what things they like, what things they don't like, things to make life easier for both your child and the person stepping into your shoes. As they approach the age of 18, the question then becomes, okay, they're looking for these benefits, but so often we hear in this area of the practice that people are being spoken to about guardianships, but really the question needs to be, how is your child managing? If they have some limitations, but they are high functioning and they're able to understand on some level legal documents and make decisions, and maybe they're not a great money manager, but they know who they would want to manage their money, and they could have a conversation with someone like me, then instead of jumping to a guardianship, you are more likely going to want to have a conversation and let us talk to your child about doing power of attorney and a healthcare proxy so that they're doing those documents and the court doesn't necessarily become the factor in their life. SSI no longer at this point of the age of 18 looks at the parent's assets and income to determine whether or not a child is eligible for SSI benefits. And again, we still want mom and dad and grandparents to look and make sure that they've updated their documents as far as their will, doing a trust, their own advance directives, and update that memorandum of intent again, because at that, years later, your child might have changed. Their likes and dislikes may be different. Their doctors may be different. You want to keep updating that. Another major threshold for an individual with disabilities is age 21. And the reason why that's so important is because Medicaid stops using the parent's assets and income as a factor in determining eligibility for your child. So you want to definitely make sure that you're making sure they're getting the fullest of benefits that they're entitled to. You want to get on Medicaid so you could start working through the OPWDD system, and that through that system there's opportunities for housing, there's opportunities for employment options. Again, as parents, you still want to keep constantly reviewing your plan and make sure your plan is consistent with what is going on with your children. So when I say that there's housing options, there's multiple ways to look at things. You have somebody that can live independently and they just need some support services, like they can live independently, and they manage well on their own, but they need someone to come in and check weekly to make sure that they're throwing out sour food and that they're maintaining things and they have a clean environment um and that they're getting their laundry done and they're worrying about their hygiene and stuff like that. So you can live independently with support services. You could also live with family, which a lot of individuals with disabilities will find their way to family members because there's a comfort there. And then there's always an opportunity, and it's a great opportunity for a lot of individuals to be in group residence because you're oftentimes with individuals who are your peers, and they they do great programs and they offer opportunities to engage daily in activities that keep the disabled individual moving and motivated and doing different things and they have that separation where they feel like they have a little bit of independence from their family, but at the same time there's supervision and guidance for them on a daily basis. So decision-making documents, which I alluded to a little bit when we were breaking down the ages, are also very important. So decision-making documents, when somebody turns 18, parents no longer have the legal right to make decisions for their children. So under 18, the parents can decide. 18 or over, it comes down to one of two things. Either the child is able to discuss and sign documents like a power of attorney, which gives the person or people that the child is naming permission to handle financial affairs for that individual. Healthcare proxy, which allows for medical decision making to be had, and a living will, which guides the agent named on the healthcare proxy to understand what that disabled individual wants in an extreme medical circumstance. So if your child is an adult and has capacity to answer those questions and engage in that conversation, then certainly advanced directives are definitely the way to go for them. If they are not able to engage in those conversations, then they can't sign those documents, and you would want to petition the court to become their legal guardian so that you have permission to do all the things that you've been doing for them. But once they turn 18, you need the court to authorize that. In becoming a legal guardian, you often get an attorney, and that attorney will help you petition the court. And the court will review all the documentation about the individual child's limitations and disability. They will give an opportunity for anybody to come in and um, if parents aren't in agreement, the court will review and make sure that there's continuity of care for the care that the child is currently receiving, and that everybody is on the same page with the care plan for that child, and that either parents are named as co-guardians or one may opt to take that role as a primary, the other as a secondary. But it is a discussion with the judge through the petition and through a hearing to discuss who's going to be named and how they're going to be named and what their role will be. Okay. These are some resources that we offer, that we just wanted to highlight for you so that you know how you can get some support in the system. And then, certainly we have a number of different webinars and seminars that we do, and we are happy to be a support for you also. I think that We are nearing the end, and I apologize if we go over a little bit. Um, so just to summarize, it's important to create a financial and legal plan for your loved ones with special needs. We discussed the role of trusts and how they are important in protecting someone's eligibility for the benefits that they are being offered. And it is an opportunity to prepare for future care and ensuring the long-term security that your child has become accustomed to. And I think that maybe there was a question or two.
We have two questions. One, how can you manage a Medicaid spend down when you have flexible income from an ebook?
So depending on the age of the person, what happens is when there's royalties coming in from an ebook, um, Medicaid will often look at the prior year's income and maybe even like the first quarter. Like if you were applying right now, they'd look at income over the last couple of months, and they will generally try and do figure it out if it were coming in monthly. So it may not be exact, but they'll look at it and say, well, if we add up the last 12 months on average, this is what has come in for the year, and this is how much it would be monthly, and they budget it that way. But Medicaid does a budget for a spend down. Pooled income trust is one of the best ways to manage that kind of income coming in, because if it's a spend down and you're going over what Medicaid is allowing, it's a little over $1,800 a month, then pooled income trust is the better way to manage that. And then we have, can someone with a pool trust earn income from self-publishing a book online, such as Amazon? The income stream will be unpredictable. So that's pretty much um, going to the same answer that we had above. And does guardianship include the ability to act on behalf of the person financially also? So with that, it depends on how the court appoints you as guardian. So the court can appoint you as guardian of the person, guardian of the property. A lot of times in a 17A guardianship, you might find that they only appoint you as the person because guardian of the property, the disabled individual doesn't always have property. And if their only financial aspect of things is SSI or Social Security disability, often Social Security will let you be the representative payee on that benefit. So you don't need guardianship of the property. So it will depend, it's how you fill out the petition. And if the disabled individual does not have assets, oftentimes the courts don't give you guardianship of the property because there is no property. All right. Um, if they suddenly come into some money and there's property again, you could go back to the court and ask for them to expand your role. How does a disabled adult become eligible for Medicare? So Medicare is attached to Social Security retirement benefits and SSDI. So a disabled individual, either they worked in the system and they are collecting Social Security disability, and after 2 years of collecting Social Security disability, they then qualify for Medicare. Or in some cases, it may be that it's an adult child who never worked in the system, but if they are disabled and never married, they can, in certain circumstances, collect Social Security disability insurance off of their parents' record. And if they start doing that, they will also be entitled to the Medicare once they're on that benefit for 2 years or more. All right. Thank you so much. Oh, wait. Medicare under the parent who is retired. So that's they have to be on it for 2 years or more, Yvonne. And then I just want to thank all of you for taking the time today. I know that this is such a big, important topic. And like I said, we are out there and we are definitely a resource for you. And keep doing what you're doing. It's such a great thing that you're doing. And don't forget to let your children and grandchildren that have disabilities inherit also. Just let them inherit in a protective way. I think that Cindy is just going to answer some of the, wrap up and give you some information about us.
Thank you, Deanna, for all that information. I just want to confirm that yes, you will receive a copy of the recording and therefore the slides. So why choose us? Russo Law Group is a firm whose clients have commended us on our dedication, accessibility, and comprehensive legal service offerings that have brought them peace of mind. We're founded in 1985 and we've serviced over 17,000 families on Long Island. We have 3 convenient locations in Garden City, Lido Beach, and Islandia. And we have 9 attorneys on staff ready to step in and help at any moment. I invite you to visit our website, bjrrussolaw.com, to further explore our service offerings. We have tons of informational content on there, such as our calendar of events and past recordings of webinars, for example. So please go and explore. I also invite you guys to follow us on our social media pages. We have a ton of informational content as well on there. Thank you for attending. You can reach out to me if you have any questions. And as Deanna mentioned, we're here to help. Deanna, I'll pass it over to you to say goodbye.
Yes, thank you all for attending. I appreciate you taking the time to listen to me. And I hope you have a great day.
Thank you. Bye.